Hey everybody, can everyone see and hear me? Did the live actually turn on? Let's see, I'll type in chat here. See me? All right. So today we're doing another live stream. We're doing it on Saturday instead of on Sunday because I'm leaving for a camping trip tomorrow. I'll be gone for a week at the summer camp, scouting camp with my son and his scout troop. We'll be up in the Sierra Nevadas near Yosemite, so it's going to be a great week. I will try to post some things from there if I can, especially if there's any breaking news, but we'll see if I have any internet or not. I don't know. Okay, so today we've got ribs on the smoker. Smoker's going. I got 2 racks of ribs. I know I did ribs last week, but my wife was gone and she really likes my ribs. So I'm making ribs again this week. I got to figure out a way to be able to do brisket for y'all because brisket takes a really long time to cook. Anyway, so on the ribs, I put on the Meat Church honey bacon barbecue rub. They're not a sponsor or anything. I just really like Meat Church. I use a lot of their products. So, what kind of wood? I see someone asking what kind of wood. Right now, it's a mixture of almond wood and oak. I've got, I use both for kind of my startup fire, and I'll probably just stick with oak throughout the rest of the cook because that's what I've got mostly split. So today I want to cover a few things. First, we'll do a quick update on the docket, and I saw some questions folks had about something that happened with the judge later on in the week, and we'll cover that. Then I want to talk about what I think Reckless Ben and the other defendants' counterclaims are going to look like. So I mentioned on one of my recent videos that I think it's a near certainty that we see counterclaims from the defendants. I don't know if they will be lodging those counterclaims in August. So that their deadline to respond to the complaint is the first week of August. I don't know if they're going to file their counterclaims then, because you can either, when you respond to a complaint, you can either file counterclaims or you can file a motion to dismiss. I think they are filing a motion to dismiss. And I think that motion to dismiss is going to include an anti-SLAPP, and it's going to include some other things. Anti-SLAPP is not itself a cause of action. It's not a counterclaim. It's not a separate lawsuit. It's a type of motion you bring to dismiss a claim. So they would either be bringing an anti-SLAPP or they would be bringing their counterclaims. Nevertheless, I think at some point they will get to counterclaims. And if they do get to counterclaims, I've got some ideas that we'll go over today on what we think those will be. If we have time after that, I want to touch a little bit about this Medina Dore case in Utah. Medina Dore is the detective. If you saw Reckless Ben's Part 3 this week, she was the detective that out of Provo that was helping everyone, helping the Bricks and Minifigs guys. And she was sued as her, among many other police officers, were sued as part of a wrongful death action a few years ago. And folks have had some questions about that. So if we've got time, I'll touch on that a little bit. So first things first, let's switch over to the docket. And I'll just pull this up here. So just to kind of update everyone with where we've been this week. So we got down here to early on in the week, so July 6th, we started off the week, remember, with a magistrate judge. On July 6th, the magistrate essentially said, I can't be the judge for the full case. The reason for that is legal. There's a law that says if a case involves injunction and a request for like a preliminary injunction, you can't have a magistrate decide those things. You need a full district court judge. So the magistrate kind of, once the parties file their joint request for the preliminary injunction, the one that takes the gag order off, the magistrate judge said, well, I can't be the person that decides that. So the case got assigned to a new full judge, Article 3 judge, Judge Barlow. I did a video on Judge Barlow, but as a refresher, Judge Barlow is, he's an Article 3 judge. He used to be the United States Attorney for Utah. He was appointed by President Barack Obama to be the U.S. Attorney. And then when it was President Trump's first term, he then appointed Judge Barlow as a district court judge. So, and when he was confirmed, I think his confirmation vote was like 80-0 or 80-10 or 80-3. I mean, it was like big bipartisan support. So it is Utah. It's a very conservative state. So he is a Republican. That's normal because even the way it works, just as a matter of practicality, is the senators from a state always kind of have, as a professional courtesy, are kind of given veto power over judicial appointments. So when Barack Obama was in office, he picked Judge Barlow, even though Judge Barlow is a Republican and Barack Obama was a Democrat, because it was Utah, and President Obama worked with the senators at the time to pick someone, and they settled on him for a U.S. attorney. President Trump likewise worked with the senators, found this guy. And because he was supported in the past by both major parties, his confirmation was basically not a big problem. Why do I talk about that? Well, because it informs us a little bit about Judge Barlow. He was viewed likely as a merits choice, someone that was going to be good for the job, someone that wasn't going to be overly partisan one way or the other. And so that strikes a good chord. I mean, obviously things are, you wait and see, but it's a good sign that he had support from both parties, because it suggests that he won't be overly biased and he'll be able to look at things without significant prejudices. So we got Judge Barlow, and Judge Barlow then within a day issued the joint preliminary injunction, got rid of the gag order, and Reckless Ben was off to the races. That same day, though, so he enters the motion for preliminary injunction July 7th. That same day, and everyone was so busy thinking about part 3 and watching part 3 that this escaped some folks' notice right away, is he issued this memorandum decision and order saying that the notice of removal does not state the citizen for each of the members of Defendant Reckless Ben LLC. What does that mean? When you're talking about a company that is called an LLC, which stands for Limited Liability Company, the word member has a very specific meaning. If I can get, there we go. The word member has a very specific legal meaning. A member, think of a member as a shareholder of like a corporation. So a member is an owner, one of the owners of the LLC. And the law says that when you are looking at removal, and if you remember my previous discussions on this, to remove to federal court, you need all the plaintiffs and all the defendants from different states. So the plaintiffs are all Utah residents or citizens, and one of them is a Delaware corporation. On the other side, all the individuals are from California or Oregon, and then you have this Reckless Ben LLC, which is a California LLC. And so if we pull up the judge's order here, is he saying that for entities other than corporations, meaning an LLC, diversity jurisdiction depends on the citizenship of the members. So Judge Barlow looked at the removal and he said, oh, I see there's an LLC here. I need to know who the owners of the LLC are and where they live to make sure removal was okay. This is not Judge Barlow being critical. It's not the court being biased against one side or the other. frankly, it's the judge having attention to detail, which is a good thing, and making sure the T's are crossed and the I's are dotted. So he says, I need to know who owns Reckless Ben LLC. Well, look, we know Reckless Ben, we know Ben Schneider owns Reckless Ben LLC. Ben Schneider is a California resident. So this is almost certainly not going to be an issue. The only time this would be an issue is if there is some other owner of Reckless Ben LLC who's either from Utah or from Delaware. And that just seems extremely unlikely. I think it's just going to be Reckless Ben owns his own LLC and he's from California. So this is just, I got quite a few questions about this in the comments and people were worried that it meant something. It really doesn't. It's just the judge having attention to detail. It's really not a big deal at all. It's almost just administrative, making sure that the paperwork gets filed correctly. So that's kind of the first thing I wanted to cover before we get into the meat and potatoes of things. First, let's look. I see we've gotten a couple super chats, so let's take a look at those and thank everyone who's been sending them. So first, Dr. Bob Gaming 1, thank you for becoming a member. Really appreciate that. And then Augusty Thompson asks, am I doing beef or pork ribs? They are pork ribs. Beef ribs, the kind of beef ribs I would cook, beef short ribs, I looked at it. It was gonna take a long time to cook those. They're big, hunky thing. And the bones are so thick and then there's a lot of meat on them. They just take hours and hours and hours to cook. And I needed something because I'm going camping tomorrow. I needed something that I could cook and eat today that's not going to keep me up till midnight cooking tonight. So, all right. So let's talk about counterclaims. I think that so I'm going to focus on two groups of who I think the counterclaims are. Reckless Ben, and what I think his counterclaims are, and also Bryan Mansell and what I think his counterclaims are. Reckless Ben's counterclaims are mostly going to come around from what we've seen in the videos, things that have been said about him and done to him. Whereas Bryan Mansell's counterclaims are mostly going to be based on how does he get the money he's owed for the Legos. Before we do that, I want to level set a little bit. We've got a few videos that I want to orient everyone to, because a lot of what I'm going to go into have to do with things that were said to police and how that creates the potential for Reckless Ben to bring a cause of action. So first thing I want to do, let's see, I'll pull this up and hopefully this is working. Make sure I'm seeing this right. Okay. So what I want to see here is this is a segment from Reckless Ben's Part 3. And what we're going to be looking at is something that Ammon McNeff, the CEO of Bricks and Minifigs, told the police about Reckless Ben.
Instead, instantly called the cops on us.
Hi there, I'm calling to report a crime.
They themselves say, hey, you guys stole this product from this person. If you don't give it back, I'm going to burn the place down. Or we're going to burn the place down. Or I'll kill you. It's Ben Snyder who's been the one engaged in this behavior.
So what we saw there was Ammon McNeff saying that it's Reckless Ben engaged in this bit. He names Reckless Ben by name. It says Reckless Ben is the one engaging in this behavior. And what is that behavior? Saying things like, making threats, we're going to burn the building down, stuff like that. So this will all play out in the court of law. I'm going to assume for the purposes of this video that this is a false statement. Okay, I understand that we haven't seen the full We haven't seen the full video. This is all edited. But I'm going to assume, I'm going to give Reckless Ben the benefit of the doubt and assume that he didn't threaten to burn the building down. So the next thing I want to touch on is some body cam footage. And this comes courtesy of the bammap.com. If you have not visited the bammap.com, I encourage everyone to take a little bit of time. The creator of that website has compiled a ton of great information, including some great body cam footage. And we're going to look here at some body cam footage of what Josh Johnson told the American Fork Police about things that Reckless Ben, things that people were doing at Reckless Ben's direction. So he's not saying here that Reckless Ben did this, but he's saying that Reckless Ben is having people do this. So let's play this.
Sent a lady in there saying, "Hey, I'm going to kill you," to the manager.
Let me jump back just a few seconds.
Identified as yours, and he won't pick him up. He won't have anything to do with it. He wants me to pay him out the $100,000. I'm not going to do that.
Yeah.
So he's contacted YouTube people. They've destroyed that business. They sent a lady in there saying, "Hey, I'm going to kill you," to the manager. "I'm going to murder you." And the man to the manager's like, "Well, get killing," you know. And obviously she didn't kill her.
Okay, so what did we hear? We heard that at first he was talking about Bryan Mansell. Bryan Mansell got this YouTuber, Reckless Ben, who then sent people to the store, quote, destroyed the business, and sent people to the store to make death threats to the employee. I'm assuming that's Amanda, the lady we saw in the videos. We've seen those. We've seen the videos from him at the store. We saw videos of him talking to Ammon McNeff. There was never any statement by Reckless Ben about killing someone, burning something down. We've seen none of that. So the problem here is that these are very likely false statements. Let's get to, there's another, before we get into the analysis, there's another statement. This actually just popped up, and it is courtesy of the BAMMAC folks again. Let me switch over to my document viewer. So we just got this. This is to orient everyone. Reckless Ben's Provo case. Bricks and Minifigs submitted some witness statements. One of those witness statements was from a man named, see if I can find it, Tucker Spanbauer. And Mr. Spanbauer, in his witness statement, and as we can see, this is sent to Medina Dore, who is the officer that was investigating things. You can see my dog back there, and I think my daughter is doing something with the dog. So Medina Dore is the person who was doing the investigation, and we saw her in part 3. So Mr. Spanbauer sends this witness statement, and he says, our IT specialist Gerhardt explained that all of our locations are independently owned and operated by franchisees, and that they need to direct their questions to the franchisee in question. He then explained to them that this was not the place nor the avenue for them to bring this up, and asked them to leave. They then continued to ask questions in a confrontational way, and Gerhardt reiterated what he said and asked them to leave. It's this last sentence I want to focus on. That they continued to ask questions in a confrontational way, and Gerhardt reiterated what he said and asked them to leave. Eventually, after much discussion, they relented and left the building. At this point, the men in left the office and exited using the elevator. So we have the body cam, or we have the security camera footage from this. So let's find that. It's at 16:15. 1 second. I'm just going to jump to that in part 3. So if we jump up to right around here. Okay.
Property, did you have to ask him more than once to leave?
Yes.
Okay.
You know, we're not leaving until we get it. And he's like, no. Like,
So Ammon's telling the police
So, I mean, fortunately, I started a little bit early. So you heard Ammon said, we had to ask him multiple times. Let me back up real quick.
that even though they
no, we're not leaving until we get it.
We're not leaving until we get it. Another direct quote from Ammon attributed to Reckless Ben.
And he's like, no.
Let's see if that's
So
actually a
Ammon's
true
telling
statement.
the police that even though they continuously told us to leave, we didn't leave. But if we go back and look at the footage of what happened, this is the reality.
So when they say go to corporate, how do we respond next time?
I have no idea. You have to take it up with them. It's your thing with them. That doesn't involve us.
Okay.
As a separate business entity, you got to take it up with them. You got to resolve it with them.
Okay, well, thanks so much, guys.
Yeah, okay, guys. Good
No,
luck.
you're good. Sweet, thank you.
So, we look at that clip. Did we see they continued to ask questions in a confrontational way, and Gerhardt reiterated what he said and asked them to leave? Eventually, after much discussion, they relented and left the building. That's not accurate. That's not an accurate, this witness statement is not an accurate representation of what we saw in the security cam footage. Now, there might have been some other discussion before then, but at least this very last point is not consistent with what was said in the witness statement, and it's not consistent with what was said by Ammon McNeff about this incident. So here's the genesis of the problem as I get into the analysis of counterclaims. The problem that we've got here, at least that Bricks and Minifigs has, is numerous statements to the police and to government agencies that appear to have significant problems being accurate or truthful, and the impact, the injuries that those allegedly false statements had to Reckless Ben. And that's where I want to go. Uh-oh, I'm seeing that it's just a blank screen. Did that not play? One second.
Hey, do you want to talk? They're on their way out. If you want me to grab them or not?
I don't know. It kind of looks like the reality of what happened is we left too early for them. They wanted to pull us back in to keep talking to us. But
Okay, maybe that didn't play. Let me go back and we'll watch it again. I apologize, guys. As one of my favorite streamers says, streaming is dynamic. So this is my second live stream. We'll watch this. We'll watch this clip one more time.
He came to the property. Did you have to ask him more than once to leave?
Yes.
Okay.
You know, we're not leaving until we get it. And he's like, no. Like,
so Ammon's telling the police that even though they continuously told us to leave, we didn't leave. But if we go back and look at the footage of what happened, this is the reality.
So when they say go to corporate, how do we respond next time?
I have no idea. You have to take it up with them. It's your thing with them. That doesn't involve us.
Okay.
As a separate business entity, you got to take it up with them. You got to resolve it with them.
Okay, well, thanks so much, guys.
Yeah, okay, guys. Good
No,
luck.
you're good. Sweet, thank you.
Hey,
Okay. So like we just saw, he was accused of being confrontational. They wouldn't leave. They wouldn't take no for an answer. And that's just not consistent. These are statements that, and by the way, what we're seeing on the screen here is Bricks and Minifigs' own security footage. This is really important, right? Because as I'm going to get into, a lot of Reckless Ben's counterclaims require a showing of malice. One way you can show malice is to show that they were making misstatements intentionally. This is Bricks and Minifigs' own security camera. They have the ability to pull this up and look at it. The people who are in this video who offered witness statements had the ability to look at them and make sure that their statements were accurate. Ammon McNeff This is his office. He had the ability to look at the security camera footage and make sure it was accurate to what he was telling the police. And when these statements go to the police and are not accurate, that's where the problem lies, because that becomes looking more like malice. So let's switch over to, I'm getting stuck? No, I see someone making a comment, burnt ribs. No, it's not burnt ribs. I guess I need to probably move my Wi-Fi. I'm like maybe 6 feet from a router, but maybe I'm trying to push too much. Can everyone hear me now? Okay. My stream chat is delayed, just an FYI. Okay. All right, so let's switch over to super chats real quick, and then I'm going to get into the analysis of what I think Reckless BAM's claims are. And yeah, apologies, folks. This is my second live stream. If we're having tech issues, I will look into them and figure out how to get a better signal here. And usually, I don't have any problem streaming really, really fast from here, but maybe I just need to put a router somewhere closer. Okay. Before we do that, let's take a look at our super chats. Someone says I need a producer. Yeah, maybe, probably I do. Sorry, guys. Okay. Fran Fitzgerald sent a gift membership. Thank you, Fran. A long-time friend of mine. The police that are not accurate. The people directly sent them to the police. If they were signed under penalty of perjury, you might have even more problems. But these are statements, we'll assume for the purpose of argument, that these are statements that they knew to be false. That alone is enough for causing issues. All right, let me check my meat real quick, and then we're going to get into the analysis. There we go. All right. We got the fire going back again. All right, so this is what I want to get into next. I want to talk about what I think the causes of action are. We'll do this in two parts. Yeah, I probably do need a solid wired Ethernet. We're going to talk about part one, which is Reckless Ben, and then we got a part two, which is Bryan Mansell. Make sure we're seeing everything good. All right. So a couple key facts. So key facts number one, a lot of Reckless Ben's counterclaims, like I said, are driven by the fact that false statements were given to the police. And the consequences of those false statements is Reckless Ben can have damages. The second key fact is that the misstatements and the false statements that were made, they led to criminal charges against Reckless Ben. They led to a warrant that took a bunch of his stuff. And then finally, that the people making these statements knew that they were false. So for the purpose of the argument, I'm going to assume all of those things. I'm sure that Bricks and Minifigs would deny this, and it's an issue that'll be litigated. But based on what we've seen, for the purposes of the analysis, which is what counterclaims can reckless Ben bring, I'm going to assume those facts. So for reckless Ben, I see basically 6 possible types of counterclaims. And again, this doesn't include anti-SLAPP, because anti-SLAPP is not a counterclaim. Anti-SLAPP is a motion you bring to dismiss claims against you. So these are what causes of action, what claims can reckless Ben bring for damages, for monetary damages against, I'm just going to keep it, to keep it simple, I'm going to kind of assume they're all one person. Bricks and Minifigs, Josh Johnson, Brandon Best, Ammon McNeff, their agents, etc. I'm just gonna, to keep things simple, we're gonna treat them as kind of one singular group of people. So I think Ben's got defamation claims, and defamation is essentially telling lies about reckless Ben, and importantly, telling lies about alleged crimes that they're saying he did that were false. Something called malicious prosecution, abusive process, false arrest, tortious interference with economic relations, and then false light. And we're going to get into what each of these are, what they require, and what I think some of the potential issues may be with the cause of action to succeed on them. So the first one I want to talk about is defamation. We've seen defamation because they have accused reckless Ben of committing defamation. So defamation requires essentially 3 or 4 things in Utah. A false statement said to a third party. In this case, we're talking about said to the police, knowing that the statements were false, and an additional kicker here is accusing him of a crime. So saying that he sent people to threaten to kill the employee in the Salem store, threatening to burn down the building. Those are all serious felonies that they're accusing him of doing, and they know that they're false. For the purposes of the analysis, I'm assuming they know those are false statements, unless they come forward with evidence to counteract the evidence that reckless Ben has come forward to. This is a claim that reckless Ben can bring against Josh Johnson, Ammon McNeff, probably not Bricks and Minifigs itself, but possibly based on statements Bricks and Minifigs put in its complaint itself. Is there a problem that they were making these statements to the police? And what about what we know as qualified immunity, qualified privilege in Utah? No, it's not a problem, because these are we're assuming that these are statements that they knew were false. They knew that reckless Ben never threatened to burn down a building. We saw the comparison between the witness statements and what actually happened on the video. Those are things that they knew or reasonably should have known were not true. So it's going to be, this is a strong claim, I think, based on false burning down buildings, false threats to murder. That's going to be a very strong cause of action for reckless Ben. So the next one is malicious prosecution. Now, malicious prosecution, I think, can be strong, but it might not be strong yet. So malicious prosecution means that the false statements that Ammon McNeff and his subordinates made caused a criminal case to open for Ben. The criminal case has to end in Ben's favor. They have to establish that there was no probable cause to make the arrest to begin with, and we have to prove malice. So the easy ones. Number 1, we know that there's a criminal case. We saw that in part 3. We know that there was malice because the statements that they used, that they put in those witness statements, were not true. Because they were not true, probable cause probably isn't there as well. But it's number 2 that becomes the kicker for this one. And what we say is that it's probably not ripe yet. It means it's too early to bring it. The criminal case in Provo has to end in Ben's favor. And if and when it does end in Ben's favor, then he is going to be able to bring this cause of action. I think one fact that's very strong is that we saw in part 3, they were talking about felonies and all these different felonies that they were going through, trying to figure out what felony they could get with reckless Ben. And then they went and they subpoenaed Google on the allegations of these felonies. Reckless Ben never got charged with a felony. He got charged with trespass. And there was one other one that's akin to trespass. They're minor misdemeanors at best. So it's a huge point in Reckless Ben's favor that we saw all these attempts to get a felony on him. They went and they did this subpoena with him on his records to try to land a felony, and they didn't get any of that stuff. And it's all based on the false statements of Ammon McNeff and his subordinates about being aggressive, threatening to burn down buildings, things like that. So I think a malicious prosecution claim for damages is a strong one as soon as and assuming Reckless Ben prevails in those trespass claims that they actually have against them. So this is a good one. The next one is false arrest. False arrest can be applied and can be leveraged against a private person. It requires 4 things. First, it requires that Ben was detained, and we know that in both American Fork and in Provo, I'm assuming in Provo, we didn't see him be arrested, but we know that there's a case against him, that he was arrested. So at least with American Fork, we know he was arrested. Obviously, that arrest was without his consent. We saw that he got swatted. They broke in, claiming that they were doing a search for stolen Legos, which made no sense. They arrested Ben and everyone in the house. Did they have legal authority? Well, the problem is they did have a warrant. It was a search warrant. It wasn't an arrest warrant. But it was based on, at least in part, it was based on false statements by Josh Johnson saying that they were going around threatening to kill people. I mean, I don't want to give American Fork a ton of credit, but imagine when the American Fork police have been told by Josh Johnson that Reckless Ben and his friends have been going around and that Reckless Ben has been deputizing, his followers, so to speak, to go into a building, into a business and threaten to murder the employees there. Well, and again, I don't want to give too much credit to American Fork, but that at least partially explains why they came in with SWAT, right? Because they thought that this guy was going around threatening to kill people. So there's a whole lot of problems with American Fork, and I'm not letting them off the hook. What I am saying is that a lot of the behavior can be explained, at least in part, by the false statements of Josh Johnson. And so I think at least an allegation of false arrest, because he was arrested during that SWAT raid, an allegation of false arrest can at least come in part based on Josh Johnson's false statements. And so this may be a cause of action that Reckless Ben can bring against Josh Johnson for the false statements he was making. The next one I want to talk about is abuse of process. So abuse of process is, I think, another big one. It requires basically 3 things. First, it requires an ulterior purpose, meaning that the here process means official channels, official services of the government. So process in this case would be basically weaponizing the Provo police based on false statements. So the ulterior purpose, and we've heard Ben say it a lot of times, he thinks that the reason why they were going to the police was so that the police would come after Ben and force Ben to be quiet. That's your ulterior purpose if he proves that. Willful misuse of the process. What is that? Well, that's a false statement. That's misstatements, knowing and intentionally lying to the police about what Reckless Ben said and did in order to get the police going after him. And finally, causing harm. Well, what is the harm here? Well, first off, Reckless Ben is facing criminal charges in Provo. To the extent this applies in American Fork, he was arrested there. He's facing criminal charges there. He's had his private data subpoenaed. All of his private records were subpoenaed by the government and taken. And so, yeah, I think there's potential abusive process here. If Reckless Ben can establish that all of this was based on false statements that Ammon McNeff and the other people who would be the defense here made, yeah, I think absolutely you've got a potential abusive process claim. So then there's 2 or 3 other potential claims that I kind of am calling secondary. The first is tortious interference with economic relations or economic prosperity. It's called different things in different states. Here, this goes to the TRO that was filed against him. That the TRO was based on, again, many false statements. It was based on protected acts by Reckless Ben, so him engaging in First Amendment speech. And I think there's a viable claim for tortious interference. Before I get into that, and a reminder, and I talked about this in a recent video, the security interest. Under Utah law, when you go to get a restraining order, if that restraining order is going to enjoin the other side's business activity or commercial activity, you're required to put up a security bond to be able to compensate that other person if it turns out the restraining order was issued in error. Here, the plaintiffs, Bricks and Minifigs, made a lot of statements about the things Ben was doing and how no security interest was needed because there's no economic interest at play here. They knew very well, because they've said over and over and over and over and over in videos that this is about Reckless Ben getting clicks for his YouTube channel to make money off of his YouTube channel. They knew that he makes his money off YouTube, and yet they told Judge Graff that there was no economic interest at play here. So that creates probably a cause of action for tortious interference. Reckless Ben was delayed for a month from posting videos that would generate economic revenues for him. And yeah, I think that leads to a tortious interference claim. Now, the amount of those damages is not something I know, because I don't know what Reckless Ben's business finances are like. I don't know how much he makes off any of this stuff. Another one is false light. And false light is very similar to defamation. I think it kind of rises and falls with defamation. That's why I've got it here. It's kind of a secondary theory. You can just kind of lump this in with defamation. And then finally, emotional distress. This isn't generally like its own cause of action. It's a type of damage. It's a type of injury you can suffer. And I'll get into emotional distress again in a little bit. So those are the ones that I think Reckless Ben can bring. What are kind of the key things that will turn on whether these causes of action, these counterclaims, survive or end? Well, number one, Ben needs to win his criminal cases. And him winning the criminal cases, first off, the malicious prosecution claim depends on him winning them. But all of the causes of action Reckless Ben has get stronger if he wins the criminal cases. The other issue is a question of privilege. Statements made to the police are typically considered privilege. You typically can't get in trouble for a statement you make to the police. The problem here is when the statements are known to be lies. So Reckless Ben needs to prove that the statements that Ammon McNeff and the other people were making about him to the police, that they knew them to be lies. I think the evidence that we've seen so far suggests that that's definitely possible. So those are kind of the big issues. Bottom line, the best case here is defamation. All the things we've heard them saying Reckless Ben did, which are just kind of absurd on their face, threatening to kill people, sending people to say they're going to murder, threatening to burn down buildings, all of that, I think defamation, bottom line, is going to be his strongest claim. So let's talk about Bryan Mansell's next, but before that, let's check. I haven't looked to see if we've got any super chats. If we do, I will cover them. It doesn't actually look like we do. So let me scan through the chat and see if I've got any major questions. Someone asked, the order for the TRO mentions Ben being on social media on its four corners, does it not? Yes, it does. But it says that he can be on social media now. From Alpha Fox Adam, Ben speaks from both sides of his mouth. Sounds like he's learning about the second part of the conditional FAFO. Look, I'm not going to say as a lawyer that everyone here has acted perfectly. I think having watched now parts 1, 2, and 3, there are things that I do not agree with Reckless Ben on. I think in my commentary on part 3, I pointed out that he was wrong about some things. Ultimately, and I'll kind of use this as a segue, ultimately, if we keep our focus on Bryan Mansell and what Bryan Mansell is owed, to me, that's what a lot of that's why I got involved in this and why I cared so much, is because to me, justice is about making Bryan Mansell whole. On their face, everyone seems to agree with that, because even Ammon McNeff has said that in interviews. Bricks and Minifigs has said that in press releases, that they want to make Bryan Mansell whole. So yeah, I'm not saying everyone here has acted perfectly, but if everyone agrees that Bryan Mansell should be made whole, why are we down this road? Why are we in federal court? Why do we have $1 million causes of action and lawsuits? Why are we looking at anti-SLAPP and counterclaims and criminal charges? Why can't these people just get in a room and exchange inventory lists? Like, that was a big part of Reckless Ben's part 3, right? Why can't these guys just show their inventory lists? Like, exchange their spreadsheets, get an accountant, and sort it out. You know, if there's a problem here when I hear folks saying they want to make Bryan Mansell whole, and at the same time, I don't see the common sense things happening. As a litigator, you know, I've been doing this for 15 years. When the solution is easy and people aren't following the easy solution, there's always a reason why. I don't know what that reason is, but there's always a reason why they don't follow the easy common sense path. Why is Bricks and Minifigs suing Bryan Mansell? Hundreds of thousands. If you add them all up, I think it's over $1 million. Why are they suing Bryan Mansell for over $1 million if they want to make him whole? They're not consistent. That's the big problem I have with what I'm seeing. So let's talk about what I think Bryan Mansell's counterclaims are. Now with Bryan Mansell, it's a little different, because I'm going to focus on what is necessary to make him whole, and why I think it is Bricks and Minifigs that has the obligation to make him whole. To level set and orient everyone here, you know, we've heard a lot of statements saying that the agreement between Bryan and Crystal Law, we've heard that that was a private agreement between them as individuals. We've heard that that was not something approved by Bricks and Minifigs. We've heard that Josh Johnson and Brandon Best didn't know anything about it. None of that matters, and I'm going to walk through why I think that. At the end of the day, there was a consignment agreement between the store, the Salem store, and Bryan Mansell. That store was then taken over by corporate. And when corporate did that, I think corporate took on all the obligations of the store. Does that mean that Crystal Law was 100% above board? I don't know. But what I know is this is how the law works. The liability passes to the store. The store owes Bryan Mansell to make him whole. If at that point the store has a dispute against Crystal Law, saying that Crystal Law unjustly enriched herself, the allegation is that she's the one that stole the Legos. If that's true, then that is a cause of action by Bricks and Minifigs against Crystal Law. It is not a defense to Bricks and Minifigs saying that they have to pay back Bryan Mansell. And I understand that that's a little convoluted, but that's how the law recognizes these things. Bricks and Minifigs took on the liability of the store by taking over the store. If they got to pay Bryan Mansell back, if they in the course of that learned that Crystal Law did something that wasn't appropriate, and that she owes money back to the business venture, or she owes, then they can go after her for that. But what they can't do is claim that because she did something, that means that somehow they're immunized from liability. It doesn't work that way, and let's get into the analysis why. So, background. February 2023 is when Crystal Law and Ben Gorman entered into their franchise agreement with Bricks and Minifigs Corporate. In November of 2023, so 9 months later, is when Bryan Mansell and the Salem store, operated by Crystal Law, owned by Crystal Law, entered into that consignment agreement. And then 1 year later is when corporate came in, terminated the franchise, and took over the store. So Bryan Mansell's claims are basically fall down into two buckets. Bucket number one, he needs to be recovered for sets that were not sold. Nobody claims that all the sets were ever sold. He either needs his sets back or he needs the value of the sets. The other allegation is that some sets were sold, but Bryan was not paid for them. In that case, the cause of action is a little bit different, but he can bring a claim to recover under the consignment agreement. So what I'm going to do is I'll talk about the two different causes of action. The first one's called conversion, and it relates to return of property or return of value property. And the second one is breach of contract for unpaid funds for those that were sold. So I'll talk about what both of those are, and then I'm going to talk about why it is that it's Bricks and Minifigs that has the liability here. So let's first talk about what the consignment agreement said. So the consignment agreement pertains to Bryan Mansell on one hand and Bricks and Minifigs Salem Keyser on the other. This is important. It's important because look at the parties to the agreement. So what I've got here, these are all screenshots from the agreement that I pulled out. The agreement was between Bryan Mansell and the store, not Bryan Mansell and Crystal Law, not Bryan Mansell and Crystal Law's individual LLC that owned the store. Bryan Mansell and the store itself. The business venture itself is who Bryan Mansell contracted with. So, point two, in that consignment agreement, all the merchandise remains the property of Mr. Mansell until sold. Anything that wasn't sold is his, and he owns it. And lastly, the transfer of rights provision, and this is where it's important. Neither party shall have the right to assign its interest in this agreement. No, I'm sorry, I read the wrong sentence. First sentence. This agreement shall be binding on any successors of the parties. That word successor is very important because a successor has a meaning under the law. When you have a business venture, here the business venture is the store, and you have one person running that business venture. And then at some point, that person stops running that business venture and another person takes over and carries on that business venture. That second person is called a successor. And that is the situation we have here. We have Crystal Law and her LLC running the business venture until November 2024. After November 2024, corporate comes in. They take over operations of the store. They take over the business venture, the store. They begin running the store. They have succeeded. They've acted as a successor to under this agreement. And so that the obligations under this agreement, think about it this way. The obligations of the agreement transfer and travel with the store itself. Whoever owns and runs the store has the obligation here. And that's what's important. So there are two additional facts that are really important to this analysis. The first you see on the screen here, I've got the screenshot. I'm sure a lot of you know this screenshot. This is a pretty famous screenshot now, right? This is the night of the takeover. This is where Kai McAllister an executive with Bricks and Minifigs is on the phone. That's Brandon Best in the room conducting the takeover, and that's Crystal Law during the night of the takeover. And I have a previous video where I play the clip, but many of you have probably heard it. Kai McAllister says, because Crystal Law is telling them, I need to pull the slips so that I know how much to pay him, meaning Bryan Mansell, because he hasn't been paid. Like, there's no dispute about this. She made sales that she hadn't paid Bryan Mansell for. And she's saying, I need to look at these slips so I know how much the store owes Bryan Mansell. And Kai McAllister responds by saying, don't worry about it. Stop worrying about that. That's no longer a you thing. That consignment liability is something Brandon will take on. Brandon is in the room when Kai McAllister says this, and Brandon says nothing. He doesn't deny it. He doesn't dispute it. He hears it, and he doesn't challenge it. That is constructive acceptance of the fact. So Kai McAllister, the executive at corporate, is on notice of the consignment. Brandon Best is on notice of the consignment. They all knew that it existed as of this moment. She had not exited the building yet. They had not executed the final takeover yet. She was still in her store, and they were on notice, so they knew that night. And so that's point one on this slide, why it matters. Point two, I've got on the left some screenshots from a letter that Bricks and Minifigs sent the same day as the takeover. And they say a few really important things. So first they say, this is your letter noting that we're terminating the agreement. Second, in the middle, BAM will be exercising all of its post-termination rights, including appraisal notice to determine fair market value, purchasing the assets of the franchise. Here's the kicker: taking over operations under the marks at the accepted location. They are saying right here, we are taking over the store. So remember I said, person A running the business venture, the store, and then person B takes over the business venture and starts running it. The liability under the consignment agreement travels with the store as it goes from owner to owner and owner. When Bricks and Minifigs says, we are taking over operations effective immediately, they take over everything. They get the good and the bad. They get the assets. They get the liabilities. They get it all. And they get the consignment agreement. So then they finally say, in lieu of you paying the total of $97,000 in addition to liquidated damages and attorney's fees, BAM is willing to assume ownership of the Salem, Oregon store. Excuse me. All of Bricks and Minifigs Salem 1's assets, including but not limited to inventory and fixtures. Second, so this is just a second statement. It's the exact same thing I said before. A second statement in the notice of termination saying we are taking over this store effective immediately. It's now our store. We are running it. The fact that they're on notice of the consignment agreement means it travels with them. They're obligated now under the consignment agreement. And if there are unpaid debts to Bryan Mansell, those traveled with the store. They under the agreement, it's the store that matters. It stays with the store, the obligations, the liabilities, etc. It all travels with the store. There was also this argument, and we've heard a few times from Bricks and Minifigs saying the consignment service was not authorized. That's not, first off, it's not true. Second off, it doesn't matter. Why doesn't it matter? It doesn't matter for the reasons I just said. The liability under the consignment agreement travels with the store. It doesn't matter whether the corporate authorized it at first or not. They took it on when they took over the store. But it's not even true, because they say here, this is, again, the franchise agreement between Crystal Law, Gorman, and Bricks and Minifigs. And it says very specifically, franchisee may also offer consignment services. So I don't know how you claim it's not authorized when your contract with your franchisee says they're authorized to do consignment services. There's some argument I've heard people saying, well, consignment services is different from consignment product. No, it's not. There's no such thing under the law. Consignment is a type of service. A consignment is not a product. The product is the subject of the consignment. A consignment service is what they were doing with the consignment contract. It was a contract for services. The service was that Crystal Law would sell Bryan Mansell's product, take a percentage, and return the rest to Bryan Mansell. That is a service. This contract says consignment service is allowed. So the notion, the argument that it's not permissible is just, it has no water with me. So, all right, so what does this mean? So I think Bryan Mansell has two causes of action. The first is what we lawyers call conversion. What is conversion? Well, conversion is basically the legal way of saying something was stolen. It pertains to physical things, not money, so you can't convert money. But you can convert products and things, physical things, real property, personal property, that kind of stuff can be converted. So the requirement to prove conversion, and this applies only to the unsold sets. So we believe that there were a bunch of sets that hadn't been sold that were in a safe or wherever they were the night of the takeover. Those still remain Bryan Mansell's. He owns them. But what does he have to prove in order to win? Well, first he has to prove that he owns the goods. How does he do that? Well, checkbox number 1, the consignment agreement says he owns them all. Checkbox number 2, I think there are spreadsheets. Checkbox 3, 4, 5, 6, etc. There's a lot of photos. And I think the sets that were his had yellow stickers. I'm pretty sure Crystal Law would testify as to which sets were his. So there's going to be witness testimony, et cetera, et cetera. So I think requirement 1 is a no-brainer. Number 2, that the corporation took control of the personal property. That happened the night of. They kicked Crystal Law out of the store. They said, we are taking over operations, and that they're taking over the entire inventory of the store, including what was in the safe. So that's true. Number 3, serious enough to pay full value. I think there will be a dispute as to how much the full value is, but that's not really an issue that's going to be about whether you can win or not. That's going to come down to a damages. The bottom line here is Mr. Mansell owned property. The corporation took control of that property and then held it out to the world as being its own property when it was not, and refused to return it upon request. So all of those things tell me conversion. Now, what if Bricks and Minifigs, and like Josh Johnson, Brandon Best said, well, we didn't really know. The statement that Kai McAllister doesn't count. We didn't really know that these were his. He didn't come in until later on. Doesn't matter. Conversion is not what we call an intent tort. You don't have to prove malice. You don't have to prove or disprove good faith. All that matters is that you intentionally took control of property, and that it turned out that the property wasn't yours. So, because the ultimate goal of this cause of action is returning the property. If person A is the rightful owner of property, person B took it, it doesn't really matter if person B took it knowing that it was person A's property. The whole point is just give it back to person A. So Bryan Mansell probably has this cause of action. Now, what happens if the defendants, here would be the Bricks and Minifigs defendants, sold those sets? Well, and so they can't return it. Well, they won't be able to return it at that point because the sets are gone. So they'll have to pay him back their value. And that's how he would get damages. So under conversion, Bryan Mansell either gets the sets back that are missing, or he gets the value back of the ones that are missing. His second major cause of action is breach of the consignment agreement itself. So what do you have to prove there? You have to prove the contract exists. You have to prove its terms, a breach, and you have to prove that you've been harmed. So does the contract exist? Yes, we looked at it. What are its terms? Well, we know that Bryan Mansell was owed a percentage of everything that was sold, and that he hadn't, and we saw Crystal Law saying she hadn't yet paid him for everything he was owed. So that tells you that that's evidence of both the terms and the breach. And by breach, that's not like a moral, like they're a bad human being saying it's a breach. It's just a matter of breach here just means there was product that was sold that needed to, the funds for which needed to be paid out for Bryan Mansell, and they were not paid out to Bryan Mansell. And that's all it means. And so, and then that also speaks to the damages, is just the value of what was actually sold, the whatever the percentage is that he was owed. He's owed the value of the sale times that percentage. That's it. So pretty easy. I think Bryan Mansell's counterclaims against Bricks and Minifigs are the strongest of the lot. I think they're even stronger than Reckless Ben's. I think it's really hard to dispute dispute what goes on here. So why is Bricks and Minifigs from a legal perspective? Why does it matter? Well, there's really four theories. The strongest theory about why it's Bricks and Minifigs that's liable is what I was saying before. There's an assumption when they say they're going to take on the consignment, that they're going to take over the operation of the store. That's what we call an express or an implied assumption of the obligation. The other strong argument is that it goes to them being a successor. Bricks and Minifigs became merely the continuation of the same business venture, of the same store. They were operating the store. So there's a few different ways. De facto merger doesn't really apply here. What I've got is these are the four ways that you can do successor liability in Utah. De facto merger doesn't really apply. What that is essentially means two companies merged. They didn't merge. One company supplanted the other company. And then whether there was a fraudulent transfer, I don't think that we have fraudulent transfer. I think there's claims for fraudulent behavior somewhere in here, but fraudulent transfer is not. We're talking about transfer of the store and whether they were doing this to avoid paying Mansell. I don't think we've got facts there yet that show that. So bottom line, these are all claims for damages that I think Reckless Ben can bring, or that Bryan Mansell can bring. What does it mean? What kind of damages? Like how much damages? Well, Ben can get what's called the presumed damages for per se definition. So he's going to be able to get economic damages for any loss he suffered. Lost income from his channel is a big one. Legal defense costs, maybe. In some situations you can get attorney's fees, but it's pretty hard. The emotional and reputational harm, I don't know if his reputation was really harmed so much, but certainly there's people out there that thinks he's a bad person. I think emotional harm and emotional damages are probably applicable here because he was arrested. He was accused of attempted arson, other things like that. I mean, all of that can kind of go to emotional. And then there's punitives as well, which punitives are, we're not giving you damages just to compensate you for your loss. We're giving you punitive damages to punish the other side above and beyond that. So I think if he's able to prove a lot of these malice claims, a lot of the defamation and intentional lies, then I think punitive damages are definitely on the table. And punitive damages can be huge against the other side. For Bryan Mansell, there's different ways you can call this in terms of what he's allowed to recover. Bottom line, Bryan Mansell gets what is necessary to make him whole. He gets the missing sets back or their value, and he gets what he was owed under the contract for the ones that had already been sold. And that's kind of the long and the short of it for Bryan. He gets to be made whole. Ben's damages are likely, especially once punitives, they're likely far higher than Bryan's. I think if Ben is able to succeed on any one of the claims we went over, it's very, very high, very, very high damages. So I think that's it for the counterclaim stuff. Let's check if we've got any. We'll check if we've got any super chats, and then there was another thing I wanted to cover, folks, and we may still have time. Is I wanted to talk about this Medina Dore case. This I guess it was the death of someone in police custody. do folks want me to talk about that? If you do, you'll hit something in the chat and we will see if folks want me to cover that. Otherwise, we'll do super chats and wrap up. So let's pull up. Okay, so we've got Dr. Wench 9310. Thank you for becoming a member. Appreciate it. Nailhead 59. Can a mediator or judge mandate BAM to end its living document practices with respect to the franchise agreement? It depends on what is in the franchise agreement. So I would have to look at the franchise agreement and see under what conditions one side or the other can modify the terms of the franchise agreement. Typically, and I'll say I've not looked at that, so I do not know what is in the franchise agreement. Typically, and a contract will have a provision in there that says that the terms of this contract cannot be modified without written consent of both parties. I don't know if this one has it in here or not. I'd have to look. But whether or not a mediator or a judge in the right circumstances, if it was before them, could block that, depends on that. Oh, looks like I've got to check my food, so hold on. So when I do this, I break down my log that's basically coal. I spin it around, shuffle it around with my shovel, and then I come put another log on it. And we'll just let that go. Check my temps. Temps are pretty good. I'll spin this around just a little bit. All right. Give that a minute and hopefully it'll light back up. Okay, next, Fly Chomper Fly for $2. Supposed to be in inventory by BAM on transfer. Where is it? It's a great question. We have seen Ammon McNeff and Josh Johnson and everyone say that they've got one and they'd be happy to show it. So why haven't they shown it? I don't know. If I was to put my cynical litigator hat on and just speculate, I think it's because that inventory they know is incomplete. They know it's not a good inventory. And if they turn it over, it will give the defendant, it'll give Bryan Mansell, Reckless Ben, whoever else sees it, the ammunition to confirm that inventory was bad. And it's just going to help prove Reckless Ben's side of the case. That's probably why they're not turning it over. AMS133, thank you for becoming a member. Appreciate it. Augusty Thompson, 3964. I cannot wrap my head around BAM not doing everything they can to make this go away, unless doing so will put them in a worse position. How though? What would admitting fault here expose them to? I don't really have a great answer for this, unfortunately, Augusty, because it's a little baffling to me as well. I don't understand why they are not, why they haven't just mediated this. I think, frankly, what we know about the McNeffs is they're a very litigious family, right? Folks are probably aware of the Legally Mine company that is all about hiding assets. Like Ammon McNeff and his brother Matt McNeff sued their father. The father then turned around and sued his own sons. When you've got a family that's willing to sue their own family members, they're very litigious. And sometimes you just have people who view litigation as the best method being overly aggressive seems to have worked for them in a lot of cases, and maybe they thought it was going to work again. Maybe they thought that they could silence reckless Ben quickly with a permanent or preliminary injunction or TRO, and they could shut him up, and this wouldn't blow up. But unfortunately, it became one of the biggest stories on the internet in 2026, and their strategy failed. That's the best I can think. Oh, GRB Chaser for $5. Can you move your insect? Oh, was it reversed? I'm sorry about that. That might have been something. I'm looking at it. I'm looking at my screen. I see the super chats right, but apologies if I wasn't showing something right. I'll check the screen, the stream afterwards and figure it out. Tanviner for $10. Thank you for your super chat. It was discovered that the Provo detector in December told Ammon McNeff on a phone call caught on body cam that there was no extortion. In February, the warrant was issued with extortion cited. My thoughts. I will qualify my answer by saying I am not a civil rights attorney, and I do not do criminal law. The concern I have is that she already stated that there was no extortion. However, they may have still been investigating potential extortion. And so maybe the explanation is that there was a gap in what we saw between the two dates that made her think, oh wait, maybe there is extortion going on, and caused her to do that subpoena. That's the only thing I can think of. Other than that, I will have to defer to those of my learned colleagues that are more versed in civil rights law. So, okay. What do we think? Do people want me to cover? I see lots of yes. Okay, I'm going to assume folks do want me to cover the wrongful death lawsuit. So let's get into that. Switch over the document. So what happened in this case? So we'll touch on the complaint here. The allegations were that a man, a relative, or a man named Jason Todd Mace, was arrested one evening. Subsequent to being arrested, but I think once he knew the police were on their way, he ingested a lethal amount of prescription pharmaceuticals. When the police arrived, and the police that arrived included Medina Dore, who is the detective from Provo in the part 3 of Reckless Ben. The police were informed that Mr. Mace had consumed a lethal amount of pharmaceuticals. Instead of doing anything about this, the allegations are this, and I'll flip through. The officers first denied a request by the Provo City Fire Department, who was on the scene, to provide medical assistance for the decedent, for Mr. Mace. And then he was taken to a hospital, but no Provo officer informed medical staff at the hospital that the decedent had consumed a dangerous amount of the prescription medication. Officer Dore, among others, were present at the decedent's medical clearance. So the allegation is that they knew he had ingested a lethal amount of pharmaceuticals, and they sat on their hands and remained silent. The allegation is he exhibited many signs of drug impairment. He vomited many times. It was known at the hospital that he had a documented history of substance abuse. He was then cleared to go to jail without any treatment for having ingested a lethal amount of pharmaceuticals. What followed from that is Mr. Mace unfortunately passed away while in police custody. So the allegations were, they brought several allegations. The first was failure to provide proper medical care, and this was a charge against all the Provo employees, including Medina Dore. This was alleged to be free from cruel and unusual punishment, violation of constitutional rights under the Constitution. And again, this is not my area of specialty, so I'm not going to have as much insight into the 1983 stuff as, like, for example, civil rights lawyer would. That's his area of specialty. But I can explain to everybody, I know enough to explain to you all what happened. So the allegation is that the police and employees of the jail knew that he had taken a dangerous level of pharmaceuticals. They said nothing, and therefore exhibited deliberate indifference to his medical condition. And of course, he then passed away. The cause of action, so second cause was not against Dore. Municipal liability, that was against the city, not Officer Dore. And so deprivation of rights, unnecessary rigor and confinement against all the employees, so including Officer Dore. So, there were several causes of action here, all of them kind of different legal ways of saying the same thing. There was a wrongful death claim against all defendants. And so the big issue here is that you're bringing these claims against police, right? And police have what's called qualified immunity. A lot of times you can't sue government employees because they're protected from liability because the government says so. I'm not the biggest fan of sovereign immunity or qualified immunity. But the government is the government, and the government typically says you can't sue us. The only time you can sue the government is when there's a gross violation of a higher law, which is the United States Constitution. States can't get out of liability. States, cities, police can't get out of liability. Oh, I gotta flip this log, hold on. All right. So they did. The defendants here, Officer Dore and her colleagues, filed a motion to dismiss. And importantly, the judge in that case was Judge David Barlow. That is the same judge that is in the current case. The one that lifted the preliminary injunction. He's the judge for reckless bend civil suit. So they brought a motion to dismiss. I am not going to go through this, a 29-page motion, but I will touch on what they were argued. So the main arguments, I think, with respect to Officer Dore, city cannot be liable unless an officer violated the Constitution. This is qualified immunity. They basically said, Judge Barlow, you need to dismiss the case because these police officers have qualified immunity. That's the gist of what they're arguing here, at least with respect to the police officers. So the Judge Barlow then issued his order. There was a hearing that I'm going to try to get into that transcript, not on this live stream. It's too dense to go in here. But Judge Barlow entered an order that granted in part the motion to dismiss, but denied it in part. And how he split that up is actually really important. So the first cause of action, so let me flip back to the complaint and we'll see what was the first cause of action. First cause of action, failure to provide proper medical care. So the judge did say that first cause of action is dismissed, but only as to defendants Carter, Groh, and Chet Watcott. So that first cause of action against Officer Dore survives. Second, third, and fourth causes of action, they were dismissed entirely. And then importantly, the eighth cause of action is dismissed without prejudice, but only as to Provo City, Defendant Carter Groh, and Defendant Chet Watcott. So if I look back and I see what was the eighth cause of action, that was, we will see here. That was the wrongful death claim. So they brought a wrongful death against all defendants, including Officer Dore. And what did the judge say with respect to the 8th cause of action? He said that it's dismissed, but only as to the city, Carter Grow, and Chet Wacott, not as to Medina Dore. So Medina Dore, basically the most important claims, the 1st and the 8th cause of action, they continued on against Officer Dore and some of her colleagues, while some of the other defendants dropped out. There were some causes of action in the middle that the court took out, but this case survived. It survived. And it survived this motion to dismiss against Officer Dore. What happened next is essentially, without getting into all the procedural history, the case settled shortly after this. There was some other stuff that happened, but to keep it simple, it settled. So there was some behind the scenes meeting, some amount of money was agreed upon, the plaintiffs were paid out, and the case went away. So we don't know the details of that settlement. It doesn't appear that they got into discovery, so Medina Dore doesn't look like she was ever deposed. But yeah, I mean, so Medina Dore, the officer in the Reckless Ben case, she was sued for wrongful death. She appears to have been successfully sued for wrongful death. Her qualified immunity was stripped, and it was stripped by the very same judge that is Reckless Ben's judge in his case. What do I think that means for Reckless Ben? Well, I do think that it is a strike in the column of not transferring this case to Oregon. We now have 2 data points on Judge Barlow. Data point number 1 was he moved rapidly to grant the joint preliminary injunction motion. He got that thing off like within a day of him becoming the judge. I think that bodes well. I guess point 2, I'll add this one in, is I think the fact that he was supported so overwhelmingly by both major political parties also bodes well. I think it's good to say that, to show that he's not biased. Number 3, the fact that he stripped qualified immunity against a police officer who is enmeshed in the current dispute, that's a pretty good fact. It's a good reason to think that they may want to keep Judge Barlow. They may not want to transfer this case to Oregon. They may figure they got a pretty good judge here, and this judge doesn't like Medina Dore, was willing to let the wrongful death cause of action proceed past qualified immunity. Those are all pretty good facts. There's a lot in this case that's going to come down to, especially if and when Reckless Ben files counterclaims. Those probably end up in Judge Barlow's court as well. And knowing that this judge is willing to strip police of qualified immunity, they may like that. They may like that. So those are just a few things that I think they will be looking at over the next several weeks. So what do I think is going to happen in this case? Well, I said in my other video this week, I think mostly we're going to be kind of living in the court of public opinion for the next few weeks. I think Reckless Ben and his team are preparing their motion to dismiss. I think that motion to dismiss will include anti-SLAPP, and it will probably include some other things in it. And then that motion gets filed the first week of August. So until then, I don't expect to see a lot of exciting things happening in the civil suit. I think we'll continue to see things happening on YouTube and social media and things like that. And once we get that motion, we will cover it. I am planning to kind of do a primer, so to speak, on anti-SLAPP and what it is. I think folks have a lot of misconceptions about anti-SLAPP and how powerful it is. I think it is certainly an applicable tool in this case. I do not think it's something that's going to take out all of the causes of action, but I do think it has a significant possibility to narrow the case and to whittle down the allegations quite a bit. So let's check in with Super Chats. it looks like we've only got one more. This is from Old Lady Pending for $5. Thank you. I would be interested in your opinion on the 5 disclaimers assigned to BAM's 2026 franchise agreement due to their litigation and financial history. I'll have to look at that. I have not looked at the 2026 franchise agreement. All the franchise agreements I've looked at are the ones that were signed, the ones that were enforced. For example, the version of the franchise agreement that applies to Crystal Law, which been in that part of the issue. So let's see. For GRB Chaser for $5, can you show us why it's good for Ben that Barlow is questioning the diversity? I don't think it's really good or bad. I think it's kind of neutral. What it tells me is that this is a judge that pays attention to detail, and I like judges that pay attention to detail. You go in a civil case, you go almost 2 years before you get to trial, and during that time, you have a judge that's going to be the primary way you argue things in federal court is through written filings, not as much at hearings. And a judge that is paying attention to detail means that he's going to read the papers carefully and be very thoughtful and deliberative. He's going to pay attention to the law, and he's going to try his best to apply the law as he sees it. All of those, I think, are good, because following a proper judicial process is always a good thing for a defendant. It means that he's not likely to be railroaded by the judge. So as a practical matter, again, why is he doing it? He's doing it because he saw that there is an LLC in the defense side of the ledger, and he just needs to make sure that the owner of that LLC is not a Utah citizen. As long as Reckless Ben files that it's a total non-event. And it's why I didn't do like a separate video or anything on it. So, all right. Any other? I think that's it for super chats. I'll try to flip through and see if we've got any other comments here to look at. Question from me and Panda 82. Does BAM charging RICO hurt BAM's case given the assumptions on evidence? It can. Yeah. I think that the way it could hurt BAM's case is if they've overpled an allegation and they're being too greedy, that can hurt their credibility with the judge. And you especially in federal court, you never want to lose your credibility with the judge, because once you lose that credibility, it's a lot harder to persuade the judge of your position on things later on. So yeah, I do think them pleading RICO, which is an abnormal thing to plead. You don't see civil RICO very often, and I think it's really odd to see it for this kind of case. I do think that can come back to bite them, because I would expect the defendants to bring a motion to dismiss against that RICO claim, because it is a hard one to maintain. Let's see. Monkey asks, can they beat the anti-slap? It depends on how and what they're trying to bring the anti-slap for. At a very high level, anti-slap is meant to go after causes of action that accuse speech, not causes of action that accuse conduct. And so let me give you a hypothetical. Let's say one of the bases for the RICO claim is speech and things that Reckless Ben said, and in another cause, another predicate fact for the anti-slap. And let's say this was true. For example, let's say Reckless Ben really did pay someone to go into a store and threaten to murder an employee. If that was the case, anti-slap is not going to protect that second thing, because it doesn't protect what are bona fide legitimate crimes, and obviously making a threat of that kind is a legitimate crime. So it's an anti-SLAPP motion can be succeeded when the real purpose of the lawsuit is to silence someone's speech. And so that's going to be the hurdle that they've got to show. Someone says, how are the ribs looking? I got to figure out a way to make my camera here a little bit more mobile and ask and take a look at that. So a couple more super chats. John Dickens, 7345 for $2. Nice afternoon chat format with barbecue. Yeah, thanks. My family's going to enjoy ribs tonight. And then we've got me and Panda for $5. Just as a thanks for taking the questions from Open Chat. Thank you so much. Thank you everyone who's given super chats and everything today. And then Fly Chomper Fly for $2. Is this case you're covering the kind to go to jury? Yes. Whether it is a criminal case or a civil case, a defendant always has a constitutional right to a jury in this country. That causes sometimes complaints because sometimes people think juries are not sophisticated enough to understand, especially if you're in like a complex technology case. They're not sophisticated enough to understand this stuff. But I'll tell you what juries are really, really good at. Juries are really good at figuring out who is BSing and who is not. Juries are really good at figuring out who's the real villain here and who's the real victim. They're really good at sussing things out. Issues of common sense are really strong with juries. I am a huge advocate and believer in the jury system because I believe that if you're going to place your fate, we're talking about if it's a criminal case, your life and your liberty, or in the case of a civil suit, it can also be some liberty. It can be damages that could be, crush your life or your business, ruin your career, things like that. Look at what happened with Johnny Depp. I think Johnny Depp's a great example. Johnny Depp was accused of defamation in the UK and in the United States. In the UK, they don't have a jury system for defamation. That was handled by a single judge. That single judge found that that Johnny Depp did in fact defame Amber Heard, and that was then wielded in public to ruin his career for many years. But in the United States, that trial came some years later. There's a jury system, and the jury went a completely different way and exonerated him. And I think that encapsulates my personal feelings about the jury system. I think having six, sometimes it's 12 men and women that have to decide an issue and have to come to a unanimous decision, I think is one of the most important rights that we have in this country. So yes, any kind of case will go to a jury. The defendant can waive their right to a jury trial. And so you could have a trial that goes just to the bench, which means the judge. If anyone has been watching the documentary on Netflix about the young lady who was driving with her friends and they got into a car accident and the friends died, but she survived. She went to a bench trial. She didn't want a jury trial, and the judge convicted her. In hindsight, I don't know if that was the smartest move. Maybe a jury would have been better for that. So you always get a jury trial. Now there is a couple exceptions to that. If you have minor municipal infractions like a speeding ticket, you don't get a jury trial for a speeding ticket. So minor things like that. But anything that's a misdemeanor or felony in a criminal case, you get a jury trial for. Any civil case, you get a jury for. Let's see, we've got some more super chats that came in. Another $5 from GRB Chaser. Thank you so much, GRB Chaser. Could there be a doth protest too much situation where BAM gets focus drawn on them for RICO? I have heard and seen folks talking about they think that maybe BAM's the one that's liable for RICO. I haven't done a complete analysis on that, but I will say I just think generally RICO is an inappropriate thing for this case. I don't see any of the facts anywhere really lending themselves towards RICO. RICO was created for the mob. It was created as a way to go after the mob. It's the fact that you have bad actors, and we'll assume for the purpose of the argument that Bricks and Minifigs is a bad actor, a bad corporation that does bad things, that fleeces their franchisees. And I'm just saying for the purpose of argument, to answer the question. Do I think even then that that's a RICO? No, I still don't really think that's RICO. I think that is, there are innumerable types and means of civil causes of action that can cover those fact patterns, and then there's statutory cause of action that can cover those types of fact patterns. I just think RICO is ultimately what we're talking about here are business disputes, and it's just inappropriate all around. So I'm not saying it's impossible, and I haven't done a complete analysis on whether you could make a case for BAM. I just think that when you're dealing with business disputes like this, it's just not what RICO was created for. So I think we saw a few Rose for $2. It's never RICO until it is. I think Rose is an advocate of the RICO theory. So I will not deign to disagree with Rose. Rose has looked into this a lot. So I will defer to Rose's analysis. Like I said, I haven't done it. I just think when we're talking about business disputes, there's other better causes of action to bring. See if there's any other questions in here. Tokair Iceland, barbecue counselor, are there repercussions if Ammon or any other gets on the chair and gets lying before the judge? Yes, but I will caution folks. Let's say he does lie on the stand. Lots of folks will be beating their fists to say perjury. Go after him for perjury. Perjury is very hard to prove. The reason why you never see perjury very often, it's really, really hard to prove. You got to prove that the thing that they said on the stand that wasn't true was a knowing lie. And the problem with that is the person on the stand can always say, look, I forgot what I said before. I forgot the facts. I just misspoke. So the repercussions probably aren't perjury. Now, what are the likely repercussions? Number one, the jury will absolutely hate him. When a jury is shown all of these contradictions, and you said this in public, but then this is what you did. You said this to Ben. You said you were going to give the inventory list, but you never did. So you said this to the police, but it wasn't correct. All of that matters because it goes to his credibility as a witness. So all of it is going to be admissible at trial, and the jury is just going to hate the guy. That's the real repercussion. Is they're not going to win their case by putting up witnesses whose honesty and credibility are so badly compromised. And you've got it with Ammon McNeff, you've got it with Josh Johnson. Their credibilities are just, and we saw a little bit of that. Their credibility is just shot. They were telling the police things that just were demonstrably not true. Brandon Best might be their best witness only because he's been smart enough not to speak in public. But the rest of them are horrible. What are you going to do? You're going to put up Kai McAllister? I mean, he's a young kid. You're going to put up Kai McAllister, who's like, yeah, I did tell Crystal Law that we were threatening them. I did tell Crystal Law that we were taking on the consignment. None of their witnesses look good for them. That's why, like, going back to some of the earlier questions, why is this case even here? I don't know. You have a side that's just very badly compromised, and maybe the plaintiffs are trying to get into the case into a place where it's in a favorable enough position for them to settle, because I think they probably do want to settle. I think the PR hit they're taking is just tremendous. The credibility hit that their witnesses all have suffered is tremendous. So. Yeah, let's see here. A couple more super chats came in. GRB Chaser for $2. How different is defrauding the court from perjury? Well, I think fraud on the court is a broader, like, more things can be a type of fraud on the court than just perjury. So perjury is really like you're on the stand or you've offered a written statement under the penalty of perjury, and that statement was false and known to be false. Fraud on the court can be all sorts of other things that aren't necessarily like perjury. Perjury is just one example of fraud on the court. No other examples immediately come to mind, but that's kind of how you think about it. Mark Nemke for $2. Best kept quiet. Yeah, Brandon Best did keep quiet. And then the problem though is you look at the video and he looks scary. He looks kind of creepy. So, I don't know. I do think Brandon Best was the smartest among them for staying quiet. So let's see if we've got any other questions. I'll grab them, but I think that's probably it for today. Punstress asks, assuming BAM is following Denton's legal advice, how could it be that bad? I don't know what legal advice Denton's is giving, and I don't know what their strategy is. Their strategy could have been a bit like Pearl Harbor. So the Japanese strategy of Pearl Harbor was do as much damage to the United States as you can early on, knowing that you don't have the resources for a protracted war. That could be something similar here. That maybe they thought that if they hit Reckless Ben hard enough on the first blow with a big enough hammer, they only needed to hit him once to make him capitulate. And maybe that's what they thought would happen. And why would they have thought that? Well, because it typically has worked. There's been many former franchisees that they've been able to bully out of their stores. So maybe that's the strategy. Maybe the lawyers' advice is always dependent upon the information given by their clients. Maybe the clients gave the lawyers bad information. Maybe they repeated some of the same false statements to the lawyers that they gave to the police. There's also what we call kind of the fog of war. You might have great legal theories and you might think your legal theories are super strong, but until they're tested in litigation by an opposing side poking holes into your theories, you never really know how strong they are. And I think what happened here is these allegations, some of them aren't bad. You look, I'm not, like I said earlier, I'm not going to say everything Ben did is something that I would have advised him to do as a lawyer. Some of it, replacing a store sign, setting up a table right in front of their business. These are things I probably would not have advised them to do. So not all of the causes of action are bad. The issue there really is what harm did it cause? If ultimately you're bringing awareness to things that the corporation did, how is it that the damage is something Ben caused versus your own actions? And that's really the problem. So those are some reasons why it might have been, the advice might be bad. All right, Alexander Blue for $10. Thank you so much. Does anti-SLAPP still exist in federal courts after Burke versus Joy? I have not looked at Burke versus Joy, but I can tell you that the general problem that some states have had, so every state has their own version of the anti-SLAPP law. There is one version called the uniform version of the law that a lot of states, including Utah, have imposed. And then there are states like California that have like a completely unique version of anti-SLAPP. The problem with anti-SLAPP, and this is something that the defendants are going to have to grapple with here, Reckless Ben and Bryan Mansell, that they're going to have to grapple with. Federal courts proceed on what's called the Federal Rules of Civil Procedure. That is the rules that govern the process of a litigation. When you have anti-SLAPP laws that are written they're primarily written to be used in a state court, they prescribe a process that should be followed. You can file this motion at this time, and that motion can include these certain things. The problem that anti-SLAPP has sometimes had in federal courts is that some federal courts have said that's a state procedural law, and it's trying to trump our federal procedural rules, and it can't. And so we're not going to let you use anti-SLAPP because you have to follow our federal rules of civil procedure, not the state's anti-SLAPP procedure. In response to those decisions, changes were made to the uniform statute and changes were made to the Utah statute to try to make it so that it's not a, quote, procedural law. so that it looks more like California's, because California's has been blessed by many federal courts. So Utah changed their anti-SLAPP law to see, hopefully, that it'll now pass and can be used in federal court. It has not yet been tested, as far as I know. And I don't know what's in Burke versus Joy. I'll look at it. But that's one issue that the defendants are going to have is anti-SLAPP isn't even an appropriate motion. I looked at the Utah anti-SLAPP motion. It seems like it's probably okay, but it hasn't been tested. And until it's been tested, we won't know for sure. So we're not sure how this judge would rule. I will say I generally feel better about this judge, Barlow, ruling on that issue than I would if the case had stayed in state court before Tony Graff. Tony Graff, the state court judge, the real problem I had with him is, first, he essentially just rubber stamped the restraining order that the plaintiffs proposed, even though it was grossly unconstitutional. And then, when the parties did come to the table and say, okay, we're going to modify it, here's the terms we've agreed to, then suddenly Tony Graff had a problem with it and was like, I'm not going to sign this for reasons that seem silly. I would not have confidence in having an anti-SLAPP motion taken to Judge Tony Graff. On the other hand, I think the way Judge Barlow looks at the world seems to indicate that he's a very strong advocate of the First Amendment, and I think that weighs in favor of anti-SLAPP, of a successful anti-SLAPP motion. So, Alexander, those are some things to think about. I'll look at the Burke versus Joy case. Thank you for bringing it to my attention. You know, there's just no easy way sometimes to stay on top of all the case law and all this stuff. I do have my own private practice, and I do not do this stuff for a living. So this is above and beyond. See, we've got some more super chats. Esco Cruz for $1.99. Do you know about Detective Dore fired ex-cop husband? I did not know about that. I'll have to look at that. Yeah, I mean, I'm trying generally to stick to the merits of the actual cases. A lot of folks have found this Detective Dore thing interesting, and she does have some cases that she's been involved in, so I kind of went down that rabbit hole a little bit. But no, I didn't know about her firing her ex-cop husband. And then Rose investigates under $2 under Erie. The fee shifting is still likely allowed, and that's talking about the fee shifting statute is for anti-SLAPP, and also Erie is a famous Supreme Court case that is kind of getting into what I was talking about a little bit. When you're applying federal law versus state law, and state procedural law versus federal procedural law, and when is something procedural versus non-procedural and can be used, et cetera, et cetera. And then the real Ishnik for $2. Thank you very much. No comment from there, but thank you for that. So, now I'm suddenly seeing jewels. So Sittinger 9072 sent Husky for 800 jewels. Thank you so much. I'm not really sure what the jewels are, how they work, but all right, Jim Burns Jr. Wish I could be a lawyer with you, barbecue counselor. Well, you could go to law school. I didn't start off being a lawyer. My undergrad was software design and engineering. I have a computer science degree. I worked for the government in California state legislature for a number of years. I interned for a congressman out in California, but I decided I didn't like it so much. Then I went to law school. I had a whole different career before going to law school. So it's not too late. It's not too late for anyone. I have a cousin who went to law school in her 30s, I think. And even when I was in law school, I had colleagues in law school that were in their 30s and 40s. So it's never too late if you're interested. All right, folks, I think that's it. We're coming up on 2 hours. This has been a wonderful stream. Oh, we just got another super chat. Nailhead59 for $5. What would put Ammon in contempt? Violating a court order. Going against an order that the court has issued is what's going to get you into contempt. So, Real Ishnik. Oh, he says the question was under the super chat. So let me find it. If I can. Oh, really? Okay. Realistic says, in a previous video, let's see. In a previous video, you mentioned removing this to federal court was easy because nobody was from the same state. Was closing the store in Oregon a potential mistake in this regard? Yeah, it would have caused problems. So the fact pattern there is that I think it was last year. Brandon Best and Josh Johnson, they had an LLC that was an Oregon LLC. And that Oregon LLC was closed, and Josh Johnson and Brandon Best continued operating a Utah LLC that then used like the same name as the one from Oregon. So that there's two things. Number one, that could have caused a problem because then you would have had one of the plaintiffs, if they were using that company, that would have been an Oregon LLC. But remember that the problem with LLCs, and this goes back to what Judge Barlow did with Reckless Ben, you have to look at the owners of the LLC. And so if Judge Barlow had done that same analysis and seen that Brandon Best and Josh Johnson were actually Utah, then perhaps it could be that it still wouldn't have been a problem. Because if the owners of the Oregon LLC were both Utah people, then maybe it's not a problem at that point. I don't know, I'd have to look at that. But yeah, I mean, bottom line, like in hindsight, it probably would have been either neutral or better for Bricks and Minifigs if they had stayed, if they had kept that company open. So, yeah. So anyways, oops. Someone says, super important, Norway or England in the game. Actually, that's a different one. And Demo, thank you for the £2 donation. I did one of those ancestry tests, and they can measure your Y chromosome, and the Y chromosome doesn't change as you go back through your male lineage. So they can actually trace the Y chromosome through the last 1,000 years. So I have a lot of English in me, but I'm also English by way of Norway. And I'm guessing if you think about what was going on around the year 1000, why there were Norwegians suddenly showing up in England. So I don't know. That's a good one. I'm sad that the U.S. got knocked out. I watched that U.S. game. They kind of did it to themselves. It was sad. A couple other non-super chats. I'll cover it. Idealistica, Terry, barbecue counselor, do you think this case will get settled and BAM will go away without repercussions? I think the case will settle. I don't know which way money's going to change hands, though. If I was willing to bet of the most likely out of a dozen different likely scenarios, I would say the settlement looks something like BAM pays Bryan Mansell what Bryan Mansell is owed, and everyone else walks away. That's what I guess the default settlement will be. We won't actually know the terms because the settlement will almost certainly be confidential. So, did I see? Talk about how the judge in Utah can handle divorces, death penalties, and civil disputes. So, there's been a lot of talk about Judge Graff being the judge on Ammon McNeff's father's divorce, and let's clarify that because I did look into this. That divorce happened, the substance of that divorce happened in like the early 2000s, like 2021 or 2022. For whatever reason, the case stayed open, but the divorce was effectively complete. I don't know why the divorce stayed open. I couldn't figure that out. In 2025, I think that because the case was still technically still an open case, it was reassigned to Judge Graff. But nothing happened. Judge Graff didn't administer the divorce. The divorce was already done. So technically the case is before him, but nothing's happened. He's just the name on the books. So he didn't actually have anything to do with that divorce. So, Cheeto341 for $4.99. Thank you for your super chat. Regarding potential Bryan counterclaims, would anything change if the bank account with proceeds from Bryan's set sales was also taken over? No. I don't think so, because the way this is going to work is Bryan Mansell has a claim against Bricks and Minifigs. Who controlled the bank account isn't relevant or important to that particular consideration. If it turned out that Crystal Law had unjustly enriched herself somehow, like she maintained sets or she personally kept money that was the store's money, then who owned the bank account may matter, because then it's going to be a dispute between Bricks and Minifigs as the rightful owner to that money and Crystal Law. It's not, Brian's not involved at that point. I know it's like this complicated thing, but that's kind of how I see the liability shaking out. So the bank account who owns it could play a relevant role in a dispute between Crystal and Bricks and Minifigs, but not between Brian and Bricks and Minifigs, I don't think. Ben said on stream he will not settle unless the chicken dance. Maybe we see the chicken dance too. I don't know if we will. I don't know if that was a joke or not. I just don't know. I don't know. All right, folks. I think we kept pushing because we kept getting questions in. Let me make sure I didn't miss anyone. No. All right, guys. I'm gonna wrap it there. Thank you all for being here. I will not be as active over the next week because, like I said at the beginning, I am off to scout camp for a scout troop. Oh, we have one more. SY Tiger 9072. What you cooking? I am cooking 2 racks of spare ribs, pork spare ribs. I do not like baby back ribs. I don't like how they cook, and I don't like the amount of meat. I love making spare ribs. I think spare ribs are great. So, anyways, like I said, I won't be as active over the next week. I will be paying attention to things if I have internet up in the mountains where I am. Maybe I'll snag some videos while I'm out in nature, and I can talk about Reckless Ben while in the woods. But with that, I will leave you all, and thanks everyone for being here today. Really appreciate it. Thank you to all the super chats. Thank you for all the participation. This has been a wild ride. I cannot believe we've got so many people watching. I mean, we peaked at like 1,300 people. We've still got almost 1,000 people watching. Thank you all so much. This has been amazing. My family and my wife are just blown away that all of you guys want to hear me talk so much. So anyways, thanks everyone. And we will catch you next time. So we'll be doing the stream next Sunday at our normal time. Not tomorrow, but a week from tomorrow. Talk to y'all soon. Bye-bye.